Hi folks, and welcome back to Contract Law. This is the video series on vitiating factors, and today's vitiating factor is misrepresentation at common law or misleading or deceptive conduct under statute. And today we shall jump into Prezi and have a quick overview. What I particularly enjoy about the misrepresentation topic is that it gives us an opportunity to examine some good little vignettes of human nature. We get to see a number of different ways that you can tell a good porky pie lie. And so it's kind of entertaining of itself. But what you rapidly note about misrepresentation at common law is that it's a bit of a beast to be reckoned with. There are rules, there are elements, there are exceptions to the elements, there are exceptions to the exceptions, and all sorts of curly twists and turns going on.
Don't go in, Jen. It's the most horrible thing I've ever seen in my life.
Whilst the remedies are okay, really the whole area was ripe for statutory intervention, and that's exactly what happened when we had the good old Trade Practices Act enacted in the 1970s, and it really did clean up this area of law very, very significantly. Now, that good old Trade Practices Act has morphed in 2010 into what we now know and love as the Competition and Consumer Act. And in that Act, Schedule 2 is the Australian Consumer Law. And in that little schedule, we have Section 18, which deals with misleading or deceptive conduct. And it's a beautiful little provision, very, very, very well loved and well used by Australian lawyers everywhere, and no doubt yourselves in due course. And it's not only friendlier to get your mind around how it all works, but it plugs the client into really a bunch of really, really good remedies that can be tailored specifically for each particular circumstance. So we'll step through misrepresentation at common law, and then everyone can breathe a sigh of relief collectively, and we'll do misleading or deceptive conduct under statute. Okay, so looking at the beast that is misrepresentation at common law, the first thing that we need to flag is that misrepresentation is a cause of action not based on a contract term. You'll recall in an earlier video series we did terms of your contract, express terms, implied terms, collateral terms perhaps. There are a number of different ways that a term, what is said or promised by one of the parties to the other, can find its way into the contract. Now, if whatever that party has promised turns out to be untrue, then you will have a breach of the contract, most likely, and you will be able to get damages in contract, most likely, if your client is lucky. However, what happens if something is said by one party to the other party in pre-contractual negotiations? The statement never makes its way into the contract as a term, and yet it's played a part in the contract actually coming into place in the first place. Then ultimately that statement ends up being untrue. Well, this is where misrepresentation is designed to provide some relief. So as I said, you're not actually suing on a contract term. You are suing on a statement that was made pre-contractually, which has tainted the entrance into the contract, and that's why it is a vitiating factor. Okay, so you are making an argument of a vitiating factor. You are not suing on a contract term. The other thing is you need to, obviously, in order to have a good cause of action in misrepresentation, the misrepresentation itself has to be reasonably substantial, and it has to be something that a reasonable person would believe and would entice them into a contract. And here there is a very real difference between puff, isn't there? Those kinds of embellishments that often get made by parties to a contract around the edges of the contract discussions to induce the other party to contract.
I have it. It's an oyster with 2 tickets to that thing you love. Look again. The tickets are now diamond. Anything is possible when your man smells like Old Spice and not a lady. I'm on a horse.
But you're aware, aren't you, where it's puff, that it's an exaggeration or a sales pitch, or the party's really, stretching a long bow, so to speak, and you're not really relying on that in any factual sense to inform your entry into the contract. So what we are looking at here is statements that are made pre-contractually. Now, let's go into the elements. Okay, the first element is that there has to be a false statement. So that immediately throws up the question, can you still be liable even if you just kept silent? Generally speaking, at common law, the cases tend to indicate that there's still got to be enough room for the doctrine of caveat emptor. So mere silence of itself normally won't constitute actionable misrepresentation. Okay. However, this is where we confront the first of our series of exceptions. You might be able to convince a court that silence was indeed an actionable misrepresentation if it falls within some of these, or at least one of these exceptions. The first one is where your silence has distorted a positive obligation. And in Krakowski and Duralinks, we had some representations being made about a certain anchor tenant that was going to be leasing a particular property, and the contract said that that contract contained the whole of the terms and conditions between the parties. In fact, there was a side agreement that was never disclosed. The silence as to that side agreement, of course, was a naughty no-no. It was a false statement. Not a statement, but it was an actual misrepresentation. Next, you might find that there is a subsequent discovery after you've made the whatever statement you've made originally, and then you've just kept quiet, even though you've subsequently found out that the statement was false. Okay, so you can't make a statement that's designed to get someone into a contract, then find out that whatever you've said is wrong, and then just keep mum. Okay, hope that they don't find out. You need to speak up in that kind of circumstance, and Lockhart and Osmond is the case that you're looking for there. Subsequently, you've made a statement. When you made the statement, it was perfectly true, no problems there, but then it later becomes untrue because of some development. If that's the case, again, you can't just keep mum and hope no one finds out. You have to actually say, oh, look, actually, that statement I made, it was right, but now, unfortunately, it turns out it's become incorrect. Next, when you have parties in a fiduciary relationship, so where one party has a particular relationship of trust and confidence, okay, weak party, and they're reposing their trust in the stronger party. In that kind of relationship, you can't just leave the party hanging, potentially misconstruing the situation by your silence. Hill and Rose, there is the case that you're looking for. Also, contracts uberame fide. Uberame fide, lovely Latin term. You can use it at your leisure because it is a legal term of art. It's not just fluff like a fortiori. It's an actual legal term of art. So contracts in vera fide are the contracts, usually insurance contracts, that require the utmost good faith, complete disclosure by one party, and then trust by the other party that complete disclosure has been made. Obviously, the person being insured has to disclose everything, particularly with things like life insurance and past history of medical problems and so on. And the insurer trusts them and relies on the full disclosure in order to take that contract of insurance and put it into effect. Wherever you have a contract with vera fide, silence is a naughty no-no. If it's going to misconstrue a situation, you can't keep silence. Gordon and Gordon is the case you're looking for there. In relation to silence, what I will say is that this is one of those craggy little areas of the common law, and the Competition and Consumer Act, the ACL, Australian Consumer Law, as I mentioned before, has really tidied this area up. And we'll be looking at silence under the ACL later on in this video series. So this is your first element. It has to be a false statement. Can be silence if you can fit it within those exceptions. The next element is that your false statement has to be one of fact. Now, that means past or existing fact. And that also means that there's a whole stack of representations that might fall outside actionable misrepresentations because of their nature. So, for example, statements of opinion may well slip through the cracks. Again, we have a series of exceptions here, which might mean that your statement of opinion does constitute an actionable misrepresentation. For example, if the representor never actually held the opinion in the first place, liar, liar. In that circumstance, well, obviously it's going to be an actionable misrepresentation. Also, where the representor held the opinion, but no reasonable person could have held that opinion.
Are you like a crazy person?
So unreasonable opinions are going to be actionable. Where the representor implied that they knew facts that justified whatever opinion it is that they're actually giving the other party. And here we have the delightful Smith and Land & House property court case. And in that case, you had Land & House contracting to buy the Marine Hotel at Walton-on-the-Naze in 1884 from one Smith, who held the title. Smith had represented that the hotel was let to a most desirable tenant, Mr. Fleck. However, what Smith didn't tell Land & House was that poor Mr. Fleck was habitually late in paying his rent. And in fact, just before the sale was completed, Mr. Fleck actually went bankrupt. So the question was obviously whether that was an actionable misrepresentation of fact or whether it was mere opinion. In that case, because Smith was the one that really had the access to knowledge of the true facts in that case, there was a suggestion when he said that Mr. Fleck was a most desirable tenant, that there was a raft of evidence underneath that representation that would support it. Unfortunately, there was none. So that's Smith and Land & House. The final one is something similar. The representor should have known the facts or was in a stronger or better position to know the facts. And there we have Esso Petroleum in Marden. And in that case, you had Esso Petroleum developing a service station site. They wanted to get Mr. Marden on board for a lease. And in the course of negotiations, they projected that the service station was likely to have a throughput of about 20,000 gallons of petrol a year. Martin thought it was a bit high, and indeed it turned out it was very high. It was only about 7,000 throughput a year. Obviously, in that kind of situation, Esso is holding itself out as the expert in the petroleum industry. They're the one that's developing the service station, and when they're going to make representations like that, they need to check the facts first. They should have known the facts. So the statement of opinion was actionable. So they are our exceptions to the general proposition that statements of opinion are not actionable. What about statements of intention or promises about the future? This is what I'm going to do. Well, if you think about it in those terms, promises as to what you're going to do in the future, generally speaking, you're going to have to actually incorporate that promise into the contract terms if you want it to be enforceable. That's the whole point of a contract term. It's a promise of something you're going to do in the future that will be legally enforceable. So statements of intention that don't make it into the contract, generally speaking, they're neither false nor true when they're made. There's just an intention that you're going to do that in the future. The main time when courts have been prepared to allow an exception to ruling out statements of intention or promises are when the statement of intention or promise is clearly never held by the person making it. And there's a lovely little quote by the judge in Edgington and Fitzmaurice that says the state of a man's mind is as much of a fact as the state of his stomach or state of his digestion. So if you say you have a sore stomach, you're representing fact. If you say that your mind is telling you you're going to do, sounds rather odd, doesn't it? Your mind is intending to do X or Y, similar kind of thing. Particularly where the statement of intention is bound up with fraud, as you can imagine that exception would be, courts are a little more lenient in allowing statements of intention to pass through as an actionable misrepresentation. And we'll go through Edgington in just a moment. Statements of law, generally, well, they used to be problematic before the David Securities case. Now, really not a problem. Statement of fact, statement of law, you can sue on both if they are misrepresented. Okay, so they are statements of fact. Obviously, the statement has to be addressed to the party misled, and here the test just goes through a couple of things to do with third-party recipients. So you have to, or your client, the plaintiff in the matter, has to be the intended recipient. So if one person is talking to another person, party A and party B, having a conversation, your party C out here, and there's a misrepresentation made by A to B, you as C can't sue on that misrepresentation. Makes sense, really, doesn't it? What about where information was passed along? This can be actionable as long as it was intended to be passed along and intended to be acted on. Commercial Banking Co. and R.H. Brown & Co. is the case that you're looking for there. So it has to be addressed to the party misled. Finally, the misrepresentation has to induce the contract. That is, it has to be intended to induce or entice the party into the contract, and it actually transpires that it did induce the other party to enter into the contract. There is your causation element, okay? If you've got a misrepresentation floating out in the wings here, but it doesn't do anything, it doesn't actually make the party enter into the contract, well, you haven't got an actionable anything, really, have you? You've just got a statement. But where it induces that party to enter into the contract, causation satisfied, and you can sue. So what are some non-inducing statements? Things like where the representee wasn't aware of the representation. Well, it goes to figure, really, doesn't it? Knew the representation was false. And a good little case there is Bissett and Wilkinson, a statement about the number of sheep that could be run on a property, where the representee didn't act on the representation. It just kind of floated out in the ether and landed on its belly, didn't do anything, didn't hurt anyone. If that's the case, then it won't be inducing the contract and not going to be actionable. Also, where the representation was not material, it's so de minimis, it doesn't really, make any, it's trifling. If that's the case, then it's not going to induce into a contract situation. However, if there are multiple factors that led to a party entering into a contract, and the statement played one role, even a small role, in that party deciding to enter into a contract, then that will be sufficient to have caused inducement, reliance, and entry into the contract. There's a lovely little case called Gould and Vagelos, and that case by the High Court says that it will be sufficient if the representation plays some part, even if only a minor part, in entering into the contract. Generally speaking, a fair inference of inducement and reliance will be where there's been the representation and then the party entering into the contract itself. The court will often infer that there has been inducement and reliance. It's often fairly obvious from the circumstances. So that is inducement, and they are the elements of an actual misrepresentation. And what I might do, we've hit the magical 15 to 20 minute mark, so I think I'll leave it here for video 1, and I'll catch you soon for video 2. Bye for now, guys.